So, welcome to Mediation, the New Possibilities Hour. It's June 25th, 2020, and we are live with Davida Brook and Kalpana Srinivasan. Today's program is part of the Will Work for Food project, as are all of our programs here on the New Possibilities Hour. Because of the important situation of food insecurity in the world, we use these programs as an opportunity to raise money for food banks worldwide. There's no charge for these programs. Rather, if you like what you see, we ask that you contribute to a food bank of your choice. Today's program is on an important topic, a seat at the mediation table, responding to diversification and diversity of counsel. And we have two fabulous lawyers to come and talk to us about this important subject. Both are partners in the Los Angeles office of Susman Godfrey L.L.P. Susman Godfrey is one of the country's leading trial litigation boutiques. And we have two outstanding partners from that firm. Davida Brook is a graduate of Stanford Law School, former law clerk to Judge Raymond Fisher of the Ninth Circuit, and has served as lead counsel in many important cases, including the case that Beats headphones against Dr. Dre and Jimmy Iovine. Kalpana Srinivasan is also a graduate of Stanford Law School and also a former law clerk to Justice Raymond Fisher of the Ninth Circuit, and also a partner in Susman Godfrey L.L.P. She serves as lead counsel on the plaintiff side in the Qualcomm antitrust litigation. And last year in the House Canary litigation, she was lead counsel and obtained a stunning verdict of $706 million. So we have two very, very experienced, prestigious, award-winning lawyers to address us today. And the subject really for us baby boomer mediators, as most of us tend to be, the question is, how do we deal with a younger and different generation of lawyers appearing as counsel, first chair, lead counsel before us? People who are younger, more diverse in terms of gender, race, ethnicity, and in many other ways. It's going to be a great learning experience for all of us, lawyers and mediators alike. So with that, Davida and Kalpana, please take it away.
Thanks very much, Jeff, for having us. We think this project is incredible, and we're really glad to be part of it and the charitable work you're doing. We also think the subject is really important, and I don't need to tell you all some of the obvious differences between being in a confidential mediation session versus being in open court or dealing face-to-face with an adversary, and it poses some different issues and opportunities, I think, to help recognize the changes in our legal profession. And so Davida and I are really excited to have the opportunity to talk to you about just some observations we have based on our own experience of others, I guess, in our generation, and who are also reflecting some of the changes in our in the legal marketplace. So we put together a kind of a list of tips that are meant to be starting points for our discussion, and we do welcome interactive discussion. By no means are we here to profess to know exactly the way to proceed on these issues. I'll start with this observation. I think a lot of successful relationships between lawyers and mediators have been built on sort of long-term relationships. A lawyer who has known a mediator for a long time, utilized a mediator in a number of cases. And so I very much understand that, and in some sense, you know, that's, we have to recognize that there's real benefits to clients in that. But it can also present challenges in terms of lawyers who are coming in as lead counsel who maybe haven't had experience with that mediator before, or have perhaps been before a mediator but more in a secondary role, and are now taking the helm and representing clients and will be more in the decision-making role or working with the client in the decision-making role. So I'll go through a couple of my tips, then I'll hand it over to Davida, and then we'll open the floor for discussion. The first is, don't assume who the lead lawyer is in your mediation, or, you know, who is serving as the client liaison. I think that it is, you know, in today's marketplace, clients reach out to lawyers for a wide variety of reasons. So it is not always the case that the most senior lawyer in the room or the person at the top of the caption page is the person who has the closest relationship with the client. And that, I understand, can be tricky for mediators to figure out who should I be communicating with, or you know, who has the ear of the client ultimately in terms of making decisions. And sometimes that may require actually having a discussion with the lawyers in advance and saying, okay, is there going to be somebody who is, you know, sort of the designated lead client representative? But I've certainly been in situations where there might have been a mistaken assumption about who that person is, and I have no problem clarifying that, but I don't think there needs to be that kind of assumption. I think that it's just as easy to find that out on the front end. You know, again, clients come in through a variety of ways. You might have somebody who has an institutional client, but the day-to-day relationship is managed by somebody who appears to be more junior on the team. And I think that's something we can all sort of collectively work on. And I'll say from the other end, it is important to the lawyer who does have the client relationship to be treated as the lawyer who has the client relationship. It can be, you know, send the wrong signal to the client about the person they've chosen or the person that they entrust to not be so recognized by the mediator in the same way. And so I think that there is both a practical element from the mediator side of, you know, you need to know who you can really talk to get a demand or get an offer or move the needle on an issue. But you also don't want to inadvertently undermine the lawyer by maybe disregarding him or her or treating him or her as being lower in the totem pole in front of that client, because it can absolutely have that effect.
Excuse me, Kalpana, this is something really that mediators and lawyers should be discussing in advance of the mediation to prevent any possible faux pas at the mediation session. What do you recommend? Do you recommend that mediators send out an email to everybody on the caption, hey, I'd like to talk to you before the mediation to learn the lay of the land, and then see who responds?
I think they could send out an email saying, I'd like to have a pre-call. Could the individuals who will be responsible for handling the mediation, the lawyers, please identify themselves and participate in the call? That might be one way to handle it. And, you know, there's always a decision made often, especially when you have a bigger team, about who's going to be involved and who's not. In my teams, the younger lawyers, I don't necessarily, associates, I don't necessarily want them distracted with mediation. I want them working on the case. So after that initial inquiry, I'll probably say, you can reach out to me and so, but we don't need to copy the whole team. But I have also been in the situation where mediators have reached out to a particular person on the team that they made a decision was the person to reach out to, and then I had to be looped in. And that's totally fine, but I think that, you know, Jeff, you're right. There's no reason to start from any assumption about that. And I get it can be a little awkward from the mediators. And how do we decide that, you know, there's 10 people on the caption, who's the right person to begin with? But I think it's a very good idea to ask up front, you know, could the lawyers who are going to be handling the mediation or dealing with the client issues participate in a pre-call? So and identify themselves. So there's no mystery about that, and it happens regularly that somebody gets the wrong email from the mediator and they're not the right person to be involved. I think that you know, the next tip I would say is that different teams and different lawyers handle presentation at mediations differently. And again, I'm not going to speak to this as maybe being a generational issue or not, but I don't think it's always the case anymore that you hear from one lawyer at the table. There may be somebody who is there to present how you came about with the damages analysis that supports a demand or an offer. There may be somebody at the mediation who really knows and has run to ground all of the issues around the willfulness claim. And I think teams do consider in advance who's going to speak, because they don't want it to be, you know, a cacophony of lawyers talking and sending different messages to the mediator. But again, I think it's really helpful to be mindful that your perceptions about who is the person who has the authority to present on behalf of the team and the client, to maybe check those at the door and let the team guide you on that, because they may want different people to have the opportunity to participate and present, and that they're, you know, they may be bringing in some lawyers to just attend and listen and learn. But I have certainly participated in mediations where I've had somebody else on my team be, you know, walk through the number crunching. Can you show us how we got to this number? You have the spreadsheet, show it to the mediator, do the math. And keep in mind that may be for client reasons, that may be for institutional knowledge reasons. It may also be an opportunity to let other lawyers on the team develop their skills in presenting at mediation. And I think as mediators, you all have the opportunity to sort of encourage that, because learning how to be in a mediation is not like a, you know, sort of a built-in skill as part of the process of becoming a partner. You know, it's not like you're an associate, write a great brief and learn how to present at mediation. It is something that we continue to cultivate in our younger lawyers and younger partners. And so I think that you know, mediators being supportive of that and recognizing that that's happening is helpful to that process, because at some point you're going to need those younger lawyers to lead the mediation.
Is that something to do with the implicit bias that some of us have toward certain types, older, male, white, any of those types of things that we need to check at the door?
You know, I think that there is a perception that lawyers who are the oldest member of the team, who may often be male and may often be white, are the lawyers that have the authority to speak. And I've certainly had that experience myself, where, you know, there's just an assumption that that's who is going to be leading the charge, or that those are the people who have the most insight into what the client wants. And, you know, as I sort of started off saying, some of it is a function of that lawyer may be the person that the mediator has had the most interactions with. Maybe they've mediated like a dozen cases together. So there's something about it that's natural to look to somebody you already know to create that rapport. That's really important for mediations to be successful. But I have seen it, you know, and again, I think it's partially a comfort thing. It's easy to go to the lawyer that you already know, or that you already know is established. But I think that you are absolutely right, Ellie, that part of the process of opening the table is putting those assumptions aside and not starting with the comfortable, familiar, you know, and we'll come back to this, but I think there's obviously a business case for you all not to do that either, because you might be turning away somebody who would use you in another matter. Davida, do you want to jump in? It seems like you had.
Yeah, I was just going to say, even in the context, I think Kalpana's point about the business case is an important one, and she'll make it. But even in the context of that particular mediation, I know different firms do things differently. And so you're going to have a different cast of characters at your mediation depending on what firms are attending. But I think one way to think about it is it's more or less safe to assume that if a firm has gone to the trouble of pulling someone out of their day-to-day docket and bringing them to an all-day mediation, they're there for a reason, right? And so your job as the mediator, I think, and frankly, I think it can be incredibly instrumental in what you're trying to do as the mediator to get a case settled, is to suss out why each person is there, right? And maybe a way to think about it that's less rooted in the gender biases and all that is just to say, at the start of the mediation, I'm really going to put some time into thinking through, why is each person in the room here, right? As Kalpana said, maybe Ed over there, he's the numbers guy, right? He's the one they've clearly brought because he's the master of the spreadsheets, and he's the one that I can go to if I really need to push the client or if I really need to get information about this particular issue. You know, whereas Sally over there, she's the one with the client relationship, and she's here if I need to whisper sweet nothings, you know, into the client's ear. And I think that can be a way to think about it. Is previously, you know, I think a lot of the thinking was, here's the lead trial lawyer. They're the person I'm going to go to for pretty much 9 out of 10 things, and everyone else is just there to support the lead trial lawyer. And I think that dynamic is shifting a little bit, right? If you've got 3 to 5 lawyers from a side in a mediation, a nice way to think about it that may just sort of help you do your job and also help you get over some of the unconscious biases that it's all so difficult for us to get over, myself included, is just to think about it that way. Why is each person here? Why did Susman Godfrey choose to bring these 4 people to the mediation? What is the goal of them being here? Clearly it was vetted by the client, right? And so what can I get from each of these people? How can I help each of these people? How do they fit into the larger puzzle of this mediation session that I'm you know, emceeing?
Yeah, I think
that's part of sound preparation, right? That the mediators really ought to be, for example, in your firm, there's a partner who I've known for almost 40 years. So it might not be unusual if I saw his name on the caption that I would call him and ask, who's coming to the mediation? What role is each person playing? What preparation should I as the mediator be doing with each person? And make sure that the whole team is involved. I think if a mediator is trying to do that only on the morning of the mediation, that mediator's already operating with one hand tied behind their back in terms of doing a proper, effective job for people.
And I think that's right, Jeff, with the exception that, as we were just talking about previously, you know, I know the person you're talking to, he's one of the best people I know, but I wouldn't necessarily, even though you have that relationship, I would check that desire to just reach out to him and to say, what do I need to know about each of the people on the caption? Because, you know, chances are that individual is on more captions out of our LA office than any lawyer at the firm, right? And he's obviously not the guy running the day-to-day on all of those cases, because that would be a Herculean and impossible task. So with the caveat that you just start by, you know, as I think you suggested, which was a great idea, sort of emailing the larger caption group, and then waiting to hear what you hear back. And then obviously if you have anything that you think you need a little bit more help navigating, a little bit more sensitive, that's where, you know, it's almost impossible to not rely on those personal relationships that you've developed over time. But just start with the general, and, you know, if Kalpana emails you back from that email, or I email you back from that email, to get it first from one of us, you know, who each person is and what role they're going to play. But I do think, as you said, and was going to be one of my points, research in advance, it can be so helpful. It's always apparent to me when I walk into a mediation whether the mediator has spent an hour digging through my bio and my resume and making a few phone calls. And it helps me trust the mediator. It helps me feel like they understand why I'm there. And it's always obvious, it's apparent.
And I think that's, I really agree with what Davida said. And it also, you know, a lot of times if you have repeat firms in front of you or repeat sets of lawyers, their roles are evolving. You might have been in a mediation where somebody was the junior partner or the lieutenant, or, you know, whatever you want to call it. But now it's a couple of years later and there's a new matter in front of you, and that lawyer may very well now be the lead lawyer. And I think it is really critical not to get wedded to, you know, your pre-existing experiences and assumptions. Each mediation is with a new client, is a new experience. And again, you know, clients come to lawyers in all kinds of ways. You know, as a junior when I was a junior partner, I had clients come to me, but I might have felt like they wanted a more senior lawyer also involved. So there certainly may have been a more senior lawyer on the pleadings. But at the end of the day, the client was looking to me to get advice about what to do. So I think that, you know, again, I think because the interactions between mediations and lawyers, a lot of that is about building trust and familiarity. That is important, but I think it can also be a crutch to not pushing further and saying, well, yeah, I've seen this, you know, this lawyer's usually been there with so-and-so, but I didn't really get to know that more junior lawyer because I already had the relationship. But now that junior lawyer is back, and it kind of seems like maybe she's in charge this time. And, you know, that again, I think, to reiterate a point I made at the start of this, because I've had this actual experience, in the big picture, beyond facilitating a great mediation, developing your business, and making sure you don't step into an implicit bias, how you treat lawyers is also important in their relationship with their clients. And I have, you know, I've certainly had situations where I felt that the mediator was, you know, talking to a lawyer who was not the chief lawyer, and not even within my firm, maybe a local counsel, asking them questions or addressing them that made it seem like they thought that person had more knowledge. So I think that's, you know, that is a real concern, because the takeaway for my client is, does this mediator not hold this lawyer in enough esteem to talk to them directly? So in addition to checking your own biases or assumptions or all of that, you also want to make sure you're not perpetuating those assumptions in front of somebody's client. And I think that's really, really important. And it's hard to explain how frustrating that can be when your client, who respects you and has handed over litigation, this very serious piece of litigation to you, has to watch your mediator go and ask somebody who's tangentially involved in the case a question, because they don't come to you, even though you are clearly the client designated lawyer. So I think that is another sort of pernicious issue, because then you're causing a whole other set of problems, which is signaling to a client that their lawyer is not, shouldn't be treated as lead, or shouldn't be treated as having a significant role in this major case event. Davida, do you want to talk a little bit about the client rep issues as well, based on your experience too?
Sure. I think it's just, you know, it's an obvious corollary to everything Kalpana has been saying, but just to state the obvious, because sometimes it's helpful to do that. I think all of the points that Kalpana has been making about the lawyers on the team apply with the same force, if not more, to the client representatives in the room, right? Don't assume who is the client representative with the authority over a particular issue, a particular area. Chuck just emailed a question on the chat about how much we're willing to share in advance. I mean, that will vary lawyer to lawyer. For me, you know, I'm willing to share quite a bit if I think it's going to help make for a successful mediation. So, and I will certainly share things with my mediators about my individual clients' proclivities, in the sense of, you know, make sure you don't be dismissive of this particular CFO. She will take it very personally. You will lose her within the first 15 minutes if you do that. So, you know, it's gonna vary person from person, but I think what's so amazing about this particular session that Jeff's put together is, and it goes to Chuck's question, what you guys are doing here, which is not getting defensive or not ignoring the issue, but just trying to ask, okay, I've got, you know, a lot of mediations coming up in front of me, and I just want to get better at this, and I want to sort of learn how to navigate these issues. It's the same thing, like just call up the lawyers and ask. And again, I think you'll get better answers, Chuck, if you've sent that all caption email to start with, and then the right person responds to you. So I'm willing to share quite a lot. It varies mediation for mediation, but I've certainly told my mediators, you know, I'll even share with them things about my co-counsel, right? Make sure that on the co-counsel team, this is the person that you address for these issues, because otherwise the mediation could go sideways, right? I want the mediation to be successful. And then
And just
another,
before you go to the next thing, Davida, on Chuck's question, I totally agree. This is like completely related to Jeff's point about preparation and what Davida says. And it actually doesn't help you to go to the wrong person, right? If you call the person you know forever and they're really not the person who knows what the client's willing to do, or have not significantly involved enough in the case to answer these questions about what the weaknesses are and what the other side's going to press on, you haven't helped yourself get ready to resolve the case. And so I think mediators have a big incentive of figuring out who the right person is so that they can have those candid discussions with, you know, the people who are in the know sufficiently in advance of the mediation to make it productive.
And
yeah, and none of this is easy or obvious, right? Chuck, I've gone so much in detail to say, this is the kind of client rep who will appreciate if you get personal and ask about their family or ask about their hobbies or interests, versus this is the client rep who will freeze up and take that as offensive, right? You're assuming that the only thing I want to talk about is my babies, right? There's, you know, we all know these are tricky subjects. We all know that there's no one right answer. So again, I think that's why it's so important. Even, you know, the head lawyer on the caption, the one that you know, the one that you've worked with before, isn't, again, everyone can't run the day-to-day of every case. Everyone doesn't have the client relationship in every case. And so finding the right lawyer on the team to talk to and to get that download in advance of the mediation, I think most lawyers are happy, even eager to give that download. They just aren't always getting the phone call.
Could I interject one thing there? Just tie it in with what you were just saying. You know, there are a lot of older guys, and I say guys because that's my personal experience with who their ego is so tied up in the fact that, you know, they're the most senior attorney in the firm anymore, or, you know, they've been doing this for years, that if you call them to ask them as opposed to sending to the whole group, I have seen people where their egos just, they want to let you think that they're in charge still of this. It gets in the way. They're not checking their ego at the door, if you will. And so your idea of sending it to the whole group and not just relying on, you know, hi, you know, Jim, Joe, Sue, you know, Mary, whoever, who happens to be the most senior person to give you the real lowdown, I think you're absolutely right.
Yeah, and it's not, you know, it's not nefarious most of the time, right? It's just people want to be valued, people want to be important, and, you know, they want to help you out. You give them a call and they want to help out their friends and they want to give the information, and for whatever human nature reason, it's not always the most natural instinct to say, you know what, actually, you should really talk to Kalpana, because Kalpana is the one with the client relationship and she's the one running the show. So I really think if you start there, start with that big group email, it can be a huge help to the lawyers, huge help to the clients, and a huge help to you folks in terms of your goals for the day.
And you know, we'll come to this now and not put it too far down the road, but it might be uncomfortable to get that email back, not from the person you know, but from a person you don't know at that firm, and then have to start a whole brand new relationship, right? It's a relationship building exercise for you all, for mediators. And so you already have a relationship with person A, but person A is really not the person you need to be building the relationship with. It's person B. And now you're in the position of kind of having to start from scratch. And I think, and I hope we all can view that as an opportunity. From the lawyer side, I understand. I look, you know, enviously at some of my colleagues who have been practicing much longer, that they have such a strong relationship that they can, you know, the mediator will call them and get the download, and they can talk candidly about the case, and they know what the mediator will share and not share and all of that. And that is the kind of relationship I want to have with the mediators that I work with. So it is, I think it's a challenge in that there's a natural tendency to want to go with what's known and comfortable, but it's also an important opportunity because it's the pipeline for your future business. And having been in some situations with mediators who I think did not appreciate that issue, they're not mediators that I would welcome going back to. And, you know, we're choosing to bring our clients' business there. Our clients generally will take our advice about what mediators to choose or at least not to choose. And we're paying for the privilege of being able to have a mediation. But I certainly don't want to do that if I think that I'm going to be undercut in front of my client. I'm not going to want to go back to that mediator. So, you know, that's a pipeline business issue, and I hope can be seen as also a business opportunity for cultivating these new relationships. Calling that person you don't know, and it's kind of, awkward at first, but doing the work to build it, not just for that case, but because over time, they may be the source of the new incoming work for you as a mediator.
And I think a corollary to all this, and it's sort of one of those things that if you don't fix it at the beginning, it just keeps on getting worse and worse, the snowball effect. I don't know, you mediators on the phone have more experience with this than me. Stepping back to one of Jeff's questions just about sort of the generational differences, I seem to be noticing that mediations are taking longer these days, right? The come into the room and get it wrapped up in a single session seems to be dragging on longer and longer. And I think all of these issues about contact and follow-up, it's true for that phase of the mediation as well, right? If by the time that first session is over, you as the mediator haven't sussed out who I need to continue to push, continue to reach out to, continue to liaise with, then the problem just sort of continues to compound, right? And some of the most successful mediations I've been in, we didn't get it done the day of, but the mediator just did such an excellent job using his time during the session, even if he couldn't get the deal struck, figuring out who all the players were, figuring out who had whose ear, so that he could keep it going after we left the room in a way that was very, very successful. I see we have some questions, so I don't want to ignore those, but.
I think David asked a question about, if you're doing all these pre-mediation communications, would that alter, maybe shift the mediator's view about the case in a way that could make them biased to a position? I mean, I think that's more a question for you all who are mediators, because I assume you do that on both sides to some degree, to get as much information as you can and to push on the hard issues from both counsel, to get a real assessment of what the risks are for each side. So I think I think the way it benefits you the most, David, is to have a lawyer who trusts you enough to tell you, yeah, that's a bad issue for us. I had a mediation recently with a mediator who I know well, and we had gotten an order that was not great for our side, that we were still working through. And the ability to be candid about the impact of that on your case is really critical. And I'm not going to do that with a mediator that I don't know and trust. I'm not going to give my candid insight about that for the mediator's perspective without that level of relationship. But I think, David, to your question, that's really, I assume, and Chuck, you might want to jump in on that, but I assume that's what you all are trying to get. You can read the papers and you can see the briefing and the legal sparring. You want to know what the real skinny is from the lawyers that maybe they don't want to put in a mediator brief to you or to the other side, but which will actually allow you to think about how you facilitate resolution.
Do you anticipate a mediator doing that in a verbal conversation or in writing? What would be your comfort zone?
I would prefer call. So we obviously submit, written materials. Most mediators like some form of that, case materials. But when a mediator calls me to want to say, look, I read all the papers, and I just would like a little more insight about how important you think this issue, or I saw reference to this structural relief. If I can't get that done, are we done for the day? And ask that kind of next level question. And of course, there's a whole other art. Jeff has told me all about the art of how much you tell your mediator. But I think that those are the kinds of questions that you feel comfortable talking about, by phone. Is your client going to walk away from the mediation if we can't get this type of relief done. And I think that, lawyers will be willing to share as much as they feel is comfortable and appropriate, but you're more likely to get more candor about that if they trust you. Like I can tell, if I feel like I could tell the mediator that, they know it's not, it's not something that they're should be sharing in a general session or to the other side, but I've shared with them enough to know that it's going to influence how they think about a mediator's proposal, perhaps. Yeah.
And frankly, David, I think that those conversations, when done verbally, are a way of beginning to build the relationship with the lawyer and build the trust relationship, right? If it's done over email, it's hard, right, to get to that place. But, especially now when we're not schmoozing and bumping into each other at all sorts of events, right? I think that picking up the phone and having a telephone conversation, I am not a fan of the Zoom for like the run-of-the-mill average checking call. But, picking up the phone and having a conversation with the lawyer is a good way to start to build those relationships, learn about them, earn their trust, and vice versa, as compared to doing it over email.
Thank you very much. That's very helpful. Both of you, Kalpana and Davida, thank you.
I've also found that a lot of lawyers are willing to say things to me without their client there than saying it in front of their client. And I was wondering if that's also a benefit of having those private conversations.
Yeah, I think so. And it's not just outside, look, the client, we all owe our duties to our clients first and foremost, but there are things you can say when it's one-on-one, whether it's because the client's not there, because your co-counsel's not there, because local's not there, you're going to get different perspectives, I think, depending on who's in the room when it happens.
I think that's totally right, Elliot. And, as Davida says, we obviously have a duty to our clients, so we're not going to say something that's contrary to their view. But you could have a scenario where your client knows there's this bad fact about them that, something that the other side can use as leverage. They know they're going to have to hear about it, but they just don't really like talking about it. But you can have a candid conversation with the mediator and say, look, we recognize this is a risk that we'd rather not go to trial and have this issue come up, even though the client sort of really doesn't like hearing about it over and over. So I totally think so. I think there are things, and there might be a level of detail. We have clients of varying levels of interest in the nitty-gritty day-to-day litigation stuff. I have clients who are like, tell me at a high level what's going on. I have others that want to probe into every line of a pleading, and so you may be able to get into something much deeper on a particular subject than the client is interested in at the mediation, and that might help to form your view about the strength of the case for the defendant.
And I think that's especially true, Elliot, and I don't know how much of the folks on this call's practice involves these sorts of cases. If there's a sensitive issue in the case that isn't just, a big commercial dispute type issue, right? I'm not talking about a patent case where it's sensitive because, there's some bad documents out there, bad facts out there. A big chunk of my practice right now is Me Too work and defamation work. And I'm sure a lot of you have spent your fair share of time doing employment, related mediations. And you'll know that with those types of cases, the issues are just personal. They're inherently personal. And I think particularly in those types of contexts and those types of circumstances, and this is becoming more and more true, going to the lawyer in the first instance to understand what can I press on, what if I press on is just going to, close this person down for me, and having some of the more difficult, sensitive conversations with the lawyer in the first instance. Honestly, just to check your tone and check the way that it's coming off and check the way that it'll be perceived, that can be a huge asset to you. I did a mediation against a Billboard 100 artist a couple of months ago now, or a year ago, with a mediator whom I love more than life. He's a dear friend, and he's fantastic, and I consider him to be quote unquote woke. And even in that one, he just tripped over himself a little bit in terms of pushing the client too far without checking with me as to what issues were sort of the landmines underneath the surface. And so I think particularly in those types of cases where you're dealing with issues that are personal and sensitive and that people feel very, very strongly about, checking in with the lawyer and then going to the client can be a good approach.
Sometimes the lawyer will even want me to help with client control, where they want me to question, not advocate, but question one of their weaker points so that they don't have to be the bearer of bad news.
Sure. No, that can be very helpful and effective, especially if you've, touched base with the lawyer and it's been explicitly clear, this is what I think you need to sort of dig in on.
Chuck asked about our 3 list of do's and don'ts for mediators with you in mediation. Okay, tip 1. It is awkward, but Jeff is exceptional at it, which is just learning to my name. It would sound so simple and obvious, but a lot of times people don't. And I understand in some situations there may not be the opportunity to have that discussion, but if I'm the lead lawyer or a key lawyer appearing before you in mediation and you haven't worked with me before, I'd sure appreciate that if you didn't feel comfortable to ask me. 2, I would say, to really try to make sure that the parties are on the same page about their goals and that you're committed to the process, because we have all had experiences of being in mediations that we need to do because we have a court order to do a mediation, and so we're all there to march through the requirements of getting it done. But I think that when a mediator makes clear that their goal is to resolve it, whether it's that day, in a month, in 2 months, in 3 months, that's really powerful for me, as opposed to, we had to get this done, we have a mediation deadline, so we're all here, let's just see where we go. I wouldn't say that's a don't, but I think that for me that says a lot, because to Davida's point, it tells me that even if we don't get it done, this mediator is invested in at least trying to resolve it, whether it's in another week, in another month, by follow-up emails, by calls. So that to me is a really, I think, a very strong message about their role in the case, as opposed to, hey, I know you all have to check this box and file something and let the court know we mediated, so we're going to do it. And then I think, obviously, a lot of the issues we've been touching on today, which is to not walk in with any presumptions about the lawyers or their sophistication or the sophistication of the clients. And I've had that issue as well. And to instead be willing to learn and open that things may be more complicated than they seem, or that there may be more to learn about in advance. Those would be
and the one that I would just add to that is it should go without saying, but I think unfortunately it doesn't for a lot of our clients, which is a lot of the clients come into the room, even if you're the mediator that their lawyer recommended, even if you're the mediator that they wanted, concerned that you have some bias to the other side, right? Whether it's to lawyers on the other side, whether it's to the issues on the other side, right? I think there's just always this fear in the part of clients that they're not getting a fair shot. And so I've seen different mediators do it different ways. I think it should be done different ways depending on the particular mediation, but some way at the outset to just establish that baseline. I'm not here for them versus you. As Kalpana said, it's part of that goal setting. I'm here to get this case settled. Whether it's done through a very, very brief joint session at the beginning, where the mediator sort of makes clear, this is going to be my voice, this is going to be my tone with everybody. But find some way at the beginning to just make clear to that client that your goal is to help get this settled in as fairly a way as possible, and you're not in either team's pocket. And I think that sometimes gets skipped over in mediations, and you go straight into the work of the day. And a lot of clients need to hear that, either because they're worried that the mediator's in the other side's pocket, or frankly, they're so confident that the mediator is in their side's pocket that they think they're gonna, be able to get away with some ridiculous result. So some sort of grounding, some sort of tone setting at the outset that, this is who I am as the mediator, this is my role, this is my relationship to these issues and parties, and I'm really just here to push both sides equally, to get this done. A random don't that's a pet peeve that's just happened to me too much as a lawyer, so I have to share it. I think a lot of the time, folks, whether it's lawyers or the mediators in the room, are trying to acknowledge and trying to appreciate the younger lawyers in the room who, disproportionately will tend to be female. And you'll get comments like, oh, Krista, she's the brains of the operation, right? Or, oh, Sally, she's like the one we're all here. They don't sit well, right? If you're only talking to that person to throw them some offhanded comment about how, oh, they're really the mastermind behind this case, the thing they're going to be thinking is, if you thought I was the mastermind behind this case, you'd be talking to me about the issues, not giving me some throwaway comment. So I would try to be conscious of those sorts of compliments. I know they come from a good place and from an effort to acknowledge and praise the, associates who got to attend, who are doing all the work. But just be careful with them. They tend to sometimes do, to not come across, I think, in the way that they're intended.
So I didn't have any other sort of prepared tips to walk through. We're happy to talk about any other issues or answer other questions. The questions have been great and really helpful, and I don't think it's an easy task to walk into a room of lawyers and sort out all the politics and the dynamics of who's in charge and who has authority. And so I don't envy you all for having to do that, but I think, as some of you have suggested, even like I think Chuck said, maybe doing a pre-mediation Zoom with counsel or something that gets the process flowing is a great idea. I would say, just from my perspective, if you're in litigation and you're going to be having cases that you're going to need to resolve, you want to know that you have mediators who know you and are willing to trust you, or if you're assigned a mediator you've never worked with before. On the plaintiff side, a lot of times, if defense, sometimes we say, okay, they're the people who are gonna have to write the check, so if they feel comfortable, maybe it's not worth fighting and letting them go that route. But that may mean I end up before a mediator I've never dealt with before. And so that doesn't mean it can't be an extremely positive experience for me, and maybe I meet a mediator I want to use again in the future. I've had that experience for sure, but that was based on feeling the mediator really made the effort to get to know us if he hadn't worked with us before, and to develop also some level of rapport with us on our side. And so I would just, I guess, part by encouraging you all to recognize you have a really important role in setting the tone for, how lawyers deal with each other on a team, but also how lawyers deal with their clients. And so even though it may require moving beyond some of the familiar to get there, it is really important for the lawyers and their relationships with their clients, and as I said, I think for the longevity of your business pipeline too.
One of the things I heard you talking about today is about building rapport and boundaries with the lawyers. What about with those parties? How do you, I mean, I find that it's important for me to research, maybe even look at their private media, the social media, about who they are, what they're interested in. And do you find that that's important in your practice as well?
I think it's really important. And I think that, you know, if you're not familiar with the client or the principals, it's a great idea to ask the lawyer too. What are they like? How many times do you think they've been in mediation? Because the last thing you want to do is start a mediation by talking to a client who you think maybe doesn't know about mediations, or, you know, addressing them at a level of sophistication that's not commensurate with their experience. And so that, you know, doesn't do well to start the relationship. And so I think it's a terrific idea to do some research on them and then ask the lawyer, you know, how often is this principal, are they in, you know, litigation all the time? Have they been to a lot of mediations? Have they resolved significant disputes before? Is there anything I need to tell them off the bat, so that you're not coming in and making presumptions that might make you come off the wrong way by saying, you know, let me explain to you the 101 of mediations, and it turns out the clients settled huge, massive 9-figure cases routinely. So I think that's really, really helpful. And again, I think the other dynamic, and Davida alluded to this too, is that, you know, some mediators will want to press hard on the bad issues. And as lawyers, we're not so sensitive to that. That we do that, we get that in court, we get that from our opposing counsel and meet and confer. So for us, having somebody criticize our case is like, okay, that's part of our job as advocates to deal with that. But I think for clients, that's not their day-to-day experience. And so, you know, letting them know or doing some research about, you know, how are they going to react to that? I'm going to push hard on this issue. How are they going to react to that? Or what's the best way for me to pitch that to them? I think that's useful too, to build your credibility, because of course they're not necessarily hearing every day from the court or from opposing counsel about this and that issue. And so you're a third party trying to earn their trust, but at the same time, giving them an objective view of some issues. And so that's also, I think, an important thing to vet for in advance.
Well, Kalpana, doesn't that still double back to the issue of preparation? And I know when I have those pre-mediation calls with the lawyers who are going to be in charge during the day of the mediation, asking about the personalities of the participants. What are they like? Are there certain approaches to which you think they'll respond positively? And are there certain approaches to which you think they'll respond negatively, to make sure that as mediators, we can stay away from those things which are likely to be hot buttons or likely to antagonize people or turn them off to the mediation process?
The other thing I've found important, besides the things we talked about, gender, race, all of these other things, is mental illness. Many times I'll find myself in a mediation where somebody in the room has a diagnosis. It might be one of the lawyers that has it. So
Hey, lawyers sometimes are a little bit off their rockers, Elliot. I'm confused.
Well, sometimes they forget to take their meds. I don't know, but I think it's an important issue, and I wonder how you guys address it.
Yeah, I think, look, I think, again, it goes back to Jeff's point about prep, and Kalpana's point about who you talk to, right? So you got to find the right person to talk to get the right debrief about the case. And in some cases, that specifically won't be the lead trial lawyer. It will be their lieutenant, because the lead trial lawyer is the one that you kind of need the inside scoop on, right? So you got to hunt out the right person to get the debrief on, and then build that trust and that rapport with the person such that they can give you the inside look right? I alluded to this before. I've done that with mediators I've trusted, right? I've said, look, I have this co-counsel. We definitely, they're co-lead counsel with me. We definitely need them on board to settle. They are a type 1 narcissist, right? And so you need to do X, Y, and Z things in order to keep them in the room and keep them at the table. So I think we're all aware that, folks have, that our colleagues and ourselves have issues and have quirks and have hurdles and have impediments. So I think, again, it goes back to finding the right person to talk to, getting good information from them by building a relationship of trust, and doing your research, doing your homework. I've had some mediators, they don't just talk to, I know that it can be a little bit awkward, but again, it's always apparent when I walk into a room and that mediator has not just read my bio, but he's kind of called up 3 people he knows who knows me and has gotten the skinny from them about, what I'm going to be like as a negotiating partner. And so I think it's the same thing. It's to the extent you can unearth it in advance, it'll be to your benefit. And I think the ways to increase your likelihood of unearthing it in advance is to find the right person to talk to and building up that relationship of trust to see whether or not they'll give you the information.
Okay, we have only about 1 minute left. We like to begin these things on time and end them on time, out of respect to everybody. Kalpana, Davida, last comments, please.
It's fantastic to have this group, and I hope that there are other like-minded mediators who are interested in exploring these issues, because I think there's a really important dialogue to be had there, which can help improve the mediation process generally, but also make it a little bit easier for new lawyers coming in to work with different mediators. So I hope this is the beginning of a bigger dialogue, and I thank Jeff for giving us an opportunity to speak to you all.
Yeah, I just want to echo Kalpana's thanks, and Jeff in particular to you. I think it's honestly, truly so hopeful for me as a young female lawyer to see that there are so many folks in, as Jeff would say, the boomer generation, who are interested in learning about how to successfully navigate these issues. I think that sometimes these conversations can be difficult because you don't leave with real tangible, like, what to do. But what I love so much about this talk is I think if there's one thing everyone can take away and frankly spread like wildfire, is just that idea that Kalpana put out about emailing everyone on the caption and not just reaching out to your contact, your buddy at the firm, but emailing everyone on the caption and seeing who comes back to you and trying that route versus just picking up the phone.
Okay. Well, thank you both very much, Davida, Kalpana. These are tremendous insights. Thanks to everybody who's on the call today. Remember, this is part of the Will Work for Food project. If you like what you saw, and how could you not, please make a contribution of whatever you can manage to the food bank of your choice. And if you are in a position of food insecurity yourself, we are happy to help raise funds to help to support the food banks to get everybody through this very difficult and challenging time in our society. Natalie, thank you so much for organizing the Will Work for Food project. Again, Kalpana, Davida, thank you very much. And with that, our presentation is concluded. Thank you all.